I welcome you to the podcast of selected judgments pertaining to Insolvency and Bankruptcy Code for the second half of May 2026. There are some very interesting judgments, and I'm sure you're going to appreciate them. Having said that, you know that Insolvency Bankruptcy Code has been amended in 2026, and a number of sections have come into force with effect from 26th May 2026. Since NCLAT and Supreme Court will be mainly on vacation during the month of June, we'll use this time to update our website. So you may not get fortnightly podcasts that we do during the month of June, and I hope you will excuse us for that. With this, I take you over to the presentation. Viewers, we are on the screen of Section 96 of Insolvency Bankruptcy Code on Guide to IBC website, which deals with the topic of interim moratorium. As you know, interim moratorium starts when an application for under Section 94 or 95 is deposited by by personal guarantor or by a financial creditor, by a creditor enforcing the guarantee of a personal guarantor. Now, interim or in our topic of interest is topic number 21, which says that Section 96 and 101 of IBC, respectively, is applicable on the directors who are saddled with the liability to discharge the compensatory obligation of the company by virtue of the use of the words any debt therein. We know the difference between moratorium under Section 14 and under Section 96 or 101. Now, personal insolvency pertains to, any moratorium or anything, it pertains to any debt, whereas Section 14 moratorium is pertaining to the corporate debtor itself. Now, this also has, the case we are dealing with, also has a topic under Section 101 of Insolvency Bankruptcy Code, which says that the moratorium provision in Part 3, the moratorium provisions under Part 3 of the IBC must be made applicable in respect of recovery of compensation in Section 138 proceedings. So, moratorium should be made with respect to recovery of compensation and under Section 138 proceedings of Negotiable Instrument Act. So that means what? In the case of a check bouncing, the concept of recovery of money, the compensation, that should get stayed. And the case we are going to deal with has a topic under Section 124 to 128. So I've put it in 128. That is Section 128. Well, the topic is Section 128 of Insolvency Bankruptcy Code stays the proceedings that seek to enforce the bankruptcy debt by bringing an action against the properties of the debtor. We know that in the case of insolvency, it is the question of giving a repayment plan. But when it is bankruptcy, you recover your debt by selling the assets of the bankrupt. So here what is stayed is enforcement of anything that has a bringing an action against the properties of the bankrupt. We are dealing with a case, fabulous case of Honorable Supreme Court, a very recent case of Dinesh Chand Surana versus UCO Bank. Civil appeal number so-and-so 26. This case spans about 150 pages. And it has analyzed the effect of check bounce, dishonor of check, and its impact with respect to directors and personal guarantors, or individual insolvency proceeding, and has traversed various topics therein. Like you will see, it comes under headings, meaning of expression, any debt, appearing in 96 or 101. If we come down, we'll see that I mean, it has, if we go to, say, for instance, in 101, analysis of P. Mohan Raj versus Shah Brothers Iswag, analysis with respect to nature of 138 proceedings. Then we have applicability of moratorium provisions of Part 3 of IBC to the proceedings of Section 138 of NI Act. Inapplicability of moratorium provisions on criminal aspects of 138 proceedings. Applicability of moratorium provisions on the compensatory aspects of 138 proceedings. Then object of the moratorium provisions of Part 2 and Part 3 of IBC. Whether proceedings in 138 NI Act are of the nature of legal action on the for recovery of money. Then you come to 96. You see, there are various topics. Whether directors are liable under Section 141 of NI Act. I mean, it is, if I try to explain this entire thing, but mind you, I have just taken only the relevant portions of the judgment, which is of interest, or which gives us the actual knowledge, the core try to become. And it is not that in 96, 101 and 128, they are all different. So just by reading one part, you won't get the full knowledge. You'll have to go through all the three parts. And then if you have time, then go through the 150 page. It's a piece of art. But now, for the sake of this presentation, let me take you over to the slide which I prepared for you. Because we have the constraint of limitation of time. So let me take you over to the slide which I prepared for you to help you understand it. Now, what does Honorable Supreme Court say? In cases where the company, being a juristic person, cannot be proceeded against due to legal or statutory impediment, it is authoritatively settled that Section 138 proceedings against the directors would survive. We know that in P. Mohan Raj it has been stated. The contradistinction between the scope and subject matter of the moratorium are under different provisions in Part 3 is necessarily different stages require differential protection standards. Because why? Part 3 deals with insolvency and bankruptcy. So moratoriums are also different. Section 96 and 101 of IBC respectively is applicable on the directors who are saddled with the liability to discharge the compensatory obligation of the company by virtue of the use of the words any debt therein. The consequence of Section 138 proceeding is criminal liability in the form of either imprisonment or fine or both. Criminal liability for the purposes of personal insolvency is excluded under Section 79, subsection 15, dealing with excluded debt. So criminal liability does not come within the jurisdiction of IBC. By Section 79, subsection 15. The rationale underlying the exclusion of some liabilities, especially those mentioned in the excluded debts under Section 79(15), is rooted in public policy consideration. Compensation cannot substitute for punishment, and a clear line must be drawn between the two, because financial compensation should not be allowed to replace punitive sentences. Money cannot possibly compensate criminal liability. So this is exactly what is mentioned here. The financial compensation should not be allowed to replace punitive sentences. A right to payment under Section 36A accrues in favor of the creditor in respect of legally enforceable debt as a whole, for which the check is drawn to discharge such debt either completely or partially. We know that. The moratorium under Section 96 of IBC operates in respect of debt, unlike moratorium provision under Section 14, which operates in respect of corporate debtor. An individual undergoing personal insolvency, the moratorium section 96 and 101 would stay the operations of recovery of compensation. So recovery of compensation would get stayed. The provision of section 90 of 138 of NI Act was not intended to be used as a recovery of debt mechanism. This is a dangerous statement. The criminal aspect of 138, the provision of section 138 of NI Act was not intended to be used as a recovery of debt mechanism. Criminal aspect of section 138 proceeding results in punishment, including imprisonment, fine, or both. Moratorium under Part 3 of IBC cannot be made applicable on the criminal aspects of 138 of NI Act. NI Act has got criminal liability aspect also. But whereas IBC is totally a civil forum, so the criminal aspect of section 138 cannot be made applicable. So moratorium will not cover you from the criminal aspect. So for 138, if there is a jail term, imprisonment term, or fine, it has to be paid. The operation of moratorium under section 124 stays any legal action proceeding in case of any of his debts. Now it is not any debts. It says any of his debts because there is a bankruptcy has started. Section 96 or 101 envisages no action on the properties of the debtor at this stage and places emphasis only on the formation of a repayment plan that would reduce and eventually eliminate statutory provision. Clear? What is the objective of 96 or 101? The repayment plan. The moratorium under section 124 stays proceedings against any property of the debtor and therefore attaches specific assets. Now, there's a big difference between any debt under insolvency norm and bankruptcy. See, in 96 or 101, it is any debt. So the idea is ultimately creation of or production of repayment plan. But whereas in 124, it states proceedings against any property of the debtor and therefore attaches specific assets. 124(1)(a) specifically stipulates that a stay shall operate on all actions against the properties of the debtor in respect of his debts. The objective of moratorium under section 124 and 128 of IBC respectively is to freeze the asset pool, the bankrupt individual. So what is the purpose? To freeze the asset pool so that the liabilities can be paid therefrom. So now we cannot have a 138 proceeding coming in unless the liability is taken into account as a claim. Section 128 of IBC states those proceedings that seek to enforce bankruptcy debt by bringing an action against the properties of the debtor. So this, you see, this particular case is a fabulous case and it covers 96, 101, 124, 128 and the way this judgment has gone, it's a landmark judgment by all means. And we should, and I'm proud to have this opportunity to present this particular case before you. So with this, we move on to the next slide. Yes, we are on the screen of section 7 of Insolvency Bankruptcy Code on Guide to IBC website. Our topic, it's actually involving one case, but the topics are two. So the case has been segregated depending on the topic. Now the topic in section 7 is topic number 72, which says that shareholders do not have locus to file section 7 petition, but a creditor certainly has. The cases of Chandrasekhar Jha and another versus Religare Enterprise Limited and others, Company Appeal so-and-so of 2023. This is a very recent judgment. Now, in this, what happened was, the case was filed by two persons. One is Mr. Chandrasekhar Jha, and another was RHC Finance Limited. Now, Chandrasekhar Jha held one share, whereas RHC Finance Limited held 70% share, and they were a creditor also. And there was also another company called Daiichi Sankyo Company Limited, which also filed a petition. So they were an operational creditor. They were an operational creditor. So there was a question whether they have locus or not. The case is segregated. It's a long judgment. It's about 69-page judgment. It has been segregated into two parts. Now let us deal with this is one part. It's very interesting read, but there is nothing common because the case has been segregated. And let us now go to section 5.8, which deals with operational debt. Our topic is topic number 81, which says that a transaction which is sham or collusive would only create an illusion that money has been disbursed to a borrower with the object of receiving consideration in terms of the time value of money, whereas the parties have different or ulterior motive. I need not repeat, it is understandable. Now, same case, both this taken together are very interesting read. In this circuitous transaction with an ARC and things have come up. So, and to go through this entire case background will take a lot of time. So, in order to curtail that and give you the precise understanding, let me stop the screen share here and take you to the slide which I prepared for you. I've read the heading, so I'm not going into it. So what the Honorable Court held was, after becoming in rem proceeding, the expression any person aggrieved in context of IBC must be held to be indicative of there being no rigid locus requirements, institute an appeal challenging an order. CIRP having stayed, the claims have not been crystallized. Appellant number 2, who is reflected as a creditor in the balance sheet of CD, has to be treated as a stakeholder. An appeal on behalf of the appellant number 2 on the ground is maintainable. You see, there were two judgments. One is class trust, and another is independent sugar, in which Supreme Court held that the court should not be rigid in terms of the who has the jurisdiction to appeal. Now, what the court necessarily needs to find out is whether the person is really aggrieved or not. So that is the question. Now, here what we found that one person it's right that a shareholder doesn't have a right to challenge a Section 7 petition. But person, if he's also, despite being a shareholder, is also a creditor. Whether it is challenged or not, that is altogether a separate question. So long he is a creditor, he has a right to, he can be aggrieved. And another person, now we'll come to that, if he is deemed to be a creditor, then he has a right. Now here, so after becoming rem, in rem proceeding, the expression any person aggrieved in context of IBC must be held to be indicative of there being no rigid locus requirements to institute an appeal challenging an order. CIRP having stayed, the claims have not been crystallized. Appellant number 2, who is a creditor in the balance sheet of CD, has to be treated as stakeholder. An appeal on behalf of appellant 2 on this ground is maintainable. Appellant Daiichi Sankyo Limited, Company Limited, has obtained arbitral award on 29/4/2016 against Mr. Malvinder Mohan Singh and Mr. Shavinder Mohan Singh and various companies floated by them. Daiichi Sankyo Company Limited has already initiated proceeding for enforcement of a foreign award before Delhi High Court, which has passed an order on 26/2/2018, wherein it has issued garnishee order against corporate debtor to the extent of rupees 184.04 crores. What is a garnishee order? Is an order to replenish the other party of a certain amount. So Delhi High Court has passed a garnishee order asking the corporate debtor to garnish 184.04 crores. So Appellant IIG Sankyo Limited is a company limited has locus to file appeal challenging the order dated 18/7/2023. His interest is also getting affected. So he has a right. Now, it was further pleaded that now we come to the circuitous transaction. It was further pleaded that an amount of 3.60 crores, which was remitted by Religare Arts Investment Management Limited on 31/3/2009, was immediately remitted on the very same day to Religare Finvest Limited, an NBFC of financial creditor. So money did not stay with the corporate debtor even for 24 hours. On the same day, Religare's one arm transferred 3.60 crores and took it in another company of the same group. A transaction which is sham or collusive would only create an illusion that money has been disbursed to a borrower with the object of receiving consideration in the form of time value of money, whereas the parties have different or ulterior motive. Adjudicating authority has not even looked into the plea that the amount was immediately transferred and did not remain even for 24 hours with the corporate debtor. There were many more dozen transactions apart from the transaction in question, where money is received from one group entity and transferred to another group entity immediately on the same day. The above transaction shows a pattern. So the company received money and in the same day was there. So it was a vehicle for transferring money from one party to the other. Transaction between Religare Arts Investment Management Limited with corporate debtor does not reflect a financial transaction entitling the financial creditor to initiate proceedings under 7 IBC. The order of adjudicating authority admitting Section 7 application cannot be sustained because this was not a financial debt. And that is why I have not put it in Section 7. Section 7 is with the locus, whereas this was a question of whether this was a financial debt or not. And that is why this is in 5A. With this, I take you over to the next slide. Viewers, you have on your screen the dashboard of Section 12A of Insolvency Bankruptcy Code on Guide to IBC website, which deals with withdrawal of application admitted under Section 7, 9 of 10. Our topic of interest is topic number 55, which says that regarding Section 12A matter, judgment of Honorable Supreme Court in Abhishek Singh versus Hutamaki PPL Limited and another 2025 SC 465 and Glass Trust Company LLC versus Baiju Ravindran and others, reported in 2025 SCC 625, should be kept in view. This case is of Chandra Prakash Lohia versus West Bengal Agro Textile Corporation Limited, another company appeal so of 2025. This is an interesting case in the sense that IRP here came to know about the initiation of CIRP, being intimated over email by the operational creditor that not only the case has been admitted, but that they wanted to settle the matter. And Form FA was duly filed. IRP did not get time to publish Form A, that is public notice inviting claim. So the matter went to NCLT. A creditor came to know about it and said that this proceeding is in rem. So going by the case, a verdict of Honorable Supreme Court in Glass Trust versus Baiju Ravindran, the 12A petition cannot be allowed. But however, NCLT allowed the petition. The matter went to NCLT. NCLAT in this elaborate judgment, which is right there in front of you, and I sincerely request you to go through this. Uh, so please go through this, and we can you will get a good understanding. So with this, I take you over to the. In order for better understanding, let me take you over to the slide which I prepared for you. The Honorable NCLAT held that IRP's case is that the application he came to know about on 23/8/25 only when he received an email from the operational creditor seeking withdrawal of CIR. IRP himself has pleaded that no publication had been made by IRP after receiving Form FA from operational creditor. He did not file. This is the very next day he was informed. The adjudicating authority by the impugned order of 27/8/2025 has allowed the application for 12A withdraw and withdrew CIRP. The procedure under Regulation 30A of CIRP Regulations 2016 for filing an application by IRP before constitution of COC does not envisage issuance of any notice by adjudicating authority to any creditor. This we all know. Honorable Supreme Court in Abhishek Singh's case held that application for withdrawal of proceeding was filed when COC was not constituted. Hence, there could not have been any other parties concerned except operational creditor, corporate creditor, and IRP. It was due to delay caused by NCLT in disposing the application, large number of creditors filed their claim. Honorable Supreme Court in Glass Trust LLC, having affirmed the law laid down by Abhishek Singh's case, no infirmity can be found in the order of adjudicating authority permitting withdrawal under 12A. Because in Glass Trust, the Honorable Supreme Court referred to Abhishek Singh's case and said that this was good. Because how can it be wrong? The COC is not formed. Nobody has filed the claim. So, CRP should be, withdrawal of CRP should be allowed. It is only because of the delay caused by NCLT other creditors have come. And most importantly, the public notice has not even been published. So, under any circumstances, 12A should be approved. So, the CIP admission order passed under 22/8/2025, before which settlement, and NCLAT also noted that the settlement had taken place much before the order of CIP initiation had been passed. So there was no question. This was an added thing for NCLAT to consider. So with this is an interesting topic, an exceptional topic under Section 12A. So let me take you over to the next case. On the screen of Section 14 of Insolvency Bankruptcy Code or Guide to IBC website. Section 14, as you know, deals with moratorium, which is declared at the time a company is admitted into CIRP. Our topic of interest is topic number 80, which says that RP needs to be vigilant to avail benefit of moratorium under Section 14. The cases of Sumit Industries Limited versus Dakshin Gujarat Bridge Company Limited, Company Appeal so of 2026. I need not reiterate that this is a very recent judgment. This is a very interesting read, an elaborate judgment, in which what happened was this is a dispute between RP and the electricity supplier, because the electricity supplier adjusted some pre-CIRP dues from the claim, from the amount which was payable by the city. Now, this thing, it's a quite a long, and the adjustments were made not once but twice. And this matter was contested and ultimately it went to NCLAT. NCLAT looked into, did a literal autopsy of the entire transaction and came to a wonderful verdict. So in order to make things simple and understandable to you, let me take you over to the slide which I prepared for you. What we see is that NCLAT has said that corporate debtor was admitted to CIRP on 20/12/2022 and simultaneously moratorium under Section 14 of the Code came into application. Since outstanding dues remained with DGVCL, issued a disconnection notice on 14/12/2022. Now, in these cases, the dates are very important. 20/12/2022, the case was admitted to CIRP. On 14/12/2022, which is prior to CIRP admission, disconnection notice was issued calling upon the corporate debtor to clear outstanding dues within 15 days, failing which electricity supply is liable to be disconnected. The office note that was initiated by SA Revenue on 14/12/22 was furnished details about the outstanding of the corporate debtor amounting to 10 crore 70 lakhs 96,739, etc. on November 22, which is payable in December 22. It is undisputed that Executive Engineer EE is the competent authority to order adjustment of security deposit. He, after due consideration, has ordered adjustment of security deposit as per norms. The decision of EE cannot be questioned vis-a-vis the authority to take such a decision of competent authority. Now, in electricity, executive engineer is the deciding authority, and when the decision is made prior to CIRP incorporation, which is on CIRP initiation, which is on 20/12/2022, and the decision was made on 14/12/2022. The respondent number one raising a bill of 10 crore 71 lakh 63,833.44 for the month of November 22 against corporate debtor paid an amount of rupees 4 crore 45 lakhs, leaving an outstanding amount of 6 crore 25 lakhs 96 so and so. That means the 4 crore 45 lakhs was adjusted, leaving a balance of 625. This amount adjusted on 14/12/2022 from the security deposit of CD lying with respondent number one, amounting to 8 crore 30 lakhs 25,606, leaving a balance of deposit of 2 crore 4 lakhs something. The respondent one bifurcated the billing for the month of December in two parts. First being the period prior to initiation of CIRP, that is 1/12/2022 to 20/12/2022. And the second, post-period insolvency, post initiation of CIRP 20/12/22 to 31/12/2022. So they broke the bill into two parts. Now, the first adjustment of 4 crore 45 lakhs cannot be questioned because it was prior to initiation of CIRP and executive engineer was the competent authority. So he did the adjustment, it cannot be done. And the total amount of the security deposit was 8 crore 30 lakh 8 crore 30 lakhs, out of which only 2 crore remained. Now the total bill amount of December 2020 bill amount of December was 7 crore 786,57,116, out of which 5 crore 8 lakhs 7,712 for the period of prior to initiation of CIRP and 277,81,462 for the period post initiation of CIRP. The respondent one adjusted the balance security deposit of 2 crore 4 lakh 28,866 against the due of prior to CIRP. Prior to initiation of CIRP of 5 crore 8 lakh 712, further leaving a balance of 3 crore 878 845 60 as payable by COs by CD pertaining to pre-CIP period. Now, this was illegal. This was not correct. This is prohibited under Section 14. Because one, this amount, this 2 crore which was adjusted, was post initiation of CIP and when moratorium was in effect. After approval of the resolution plan by adjudicating authority, respondent number 1 received the amount of 7.24 lakhs under the approved resolution plan against the aforesaid admitted claim of CIP proceedings. The resolution professional accepted the claim form, admitted the claim, and continued making monthly electricity payments thereafter. IA 47 of 2024 was filed before adjudicating authority after approval of resolution plan by COC, despite the fact that appellant RP was fully aware of adjustment of security deposit by DGVCL and related issues. So, it is the mistake of the RP. He did not notice that post commencement of CIRP, certain security deposit was adjusted, and which he could have contested. And he would have definitely got the relief. But he contested the other one, on which was done prior to initiation of CIRP. And that's where he went wrong. So had he been vigilant, this 2 crore adjustment wouldn't have taken place. So that is what makes this case as interesting. So with this, I take you over to the next case. We often come across a situation when a person says yes and no simultaneously or at the same time. And that is the basic reason why most of the disputes take place. Now, we are on the dashboard of Section 30 of Insolvency Bankruptcy Code, which deals with submission of resolution plan. Our topic of interest is topic number 88, which says that a person cannot say at one time that a transaction is valid and thereby obtain some advantage, and then turn around and say that it is void for the purpose of securing some other advantage. That is approbate and reprobate the transaction. Exactly what I told you. We are dealing with the case of Sanjay Dave versus Andhra Bank Limited, civil appeal suits of 2024. This is a very recent judgment. In this case, what happened is a resolution plan was approved and the RP, as required under the law, issued an LOI. The SRA, instead of acknowledging or accepting the LOI, said that the LOI was conditional and did not accept the LOI. Again, another LOI was issued. He did not accept it. And he kept on objecting. The performance security was not submitted. And ultimately, the matter the company went into because the resolution plan was not approved. So, the COC decided that let the company go into liquidation in such case. So based on this, so you will find the topic, and there is also a topic in liquidation as well, which says that COC in its commercial jurisdiction can prove liquidation of the company. So this is a Supreme Court judgment, which is very important, and for the first time, there must have been, but in Insolvency Bankruptcy Code, Supreme Court has very categorically held what is appropriate and reprobate. And this is a beautiful judgment extending of 32 pages. You won't have to read 32. You may, of course, you're welcome to read 32 pages, but you can see the excerpts of the judgment, that is the relevant parts of the judgment, on the website. And I would strongly recommend that you please go through it. With this, let me take you over to the slide which I prepared for you. Honorable Supreme Court said the stand of the appellant that the stipulated clause objected by the objected to by the appellant made the LOI conditional is bereft of any merit. All that stipulation mentioned was that LOI would be subject to final decision of the judicial body in a proceeding to which COC and RP were privy to. The LOI cannot say that your resolution plan is approved. It only says that your resolution plan is approved by COC. But then it is subject to final approval of the adjudicating authority, to which COC and RP are only privy. They don't have any control. Moreover, a perusal of the minutes of the meeting of COC make it evident that appellant was very well made aware of the pending litigation and other conditions which the LOI have allegedly imposed on the applicant. The condition with regard to underwriting risk of staff and workers in any proceeding litigation cannot be said to be a conditional one on the facts of the present case. The appellant in the 27th COC meeting agreed to the same. So in the LOI, it was mentioned, in the second LOI, it was mentioned that he will take over the workers' litigations pertaining to workers and things. He will undertake it. And this was specifically mentioned in the 27th COC meeting, which he attended, and he did not object. Now, when LOI was issued, he was objecting to the same. Under RFRP, the time stipulated for issuance of performance guarantee was 7 days. It is beyond the cavil that appellant had not just acquiesced, but agreed expressly to so-called contingencies that would fall upon him as per the LOI. A person cannot say at one time that a transaction is valid and thereby obtain some advantage, and then turn around and say that it is void for the purpose of securing some other advantage. That is to appropriate and reprobate a transaction. The device adopted by appellant was indirect attempt to renege from the plan, and it was clear subterfuge. If such artifices are allowed to succeed, the entire architecture of IBC would crumble, and the laudable object sought to be achieved by the said code would become a far cry. Once COC, after applying its commercial wisdom, has approved the resolution plan, the SRA is prohibited from negotiating further and is expected to act in time-bound manner to implement the plan. We are well aware of all this. There was no illegality in the RP forfeiting EMD of 1 crore. Once the COC has, in its commercial wisdom, come to the decision to reject appellant's plan and liquidate the CD on account of appellant's own default, there can be no case for interference. So we can understand that COC, in its commercial wisdom, can order. And the appellant was just trying to play around, so which was caught by Supreme Court. And Supreme Court showed him the door. So with this is an interesting read. So with this, let us move on to the next case. We are in the midway of our presentation. I hope you are liking the presentation. Please like our video, share your comments, because your likes do motivate us to perform better. With this, I take you over to the next arm. We are on the screen of section 33, which deals with initiation of liquidation. Our topic of interest is topic number 45, which says that unexplained delay in CIRP may lead to liquidation despite resolution plan being approved by COC. This is a dangerous topic. Unexplained delay in CIRP may lead to liquidation despite resolution plan being approved by COC. The cases of Lorenzo Vitrified Tiles Private Limited versus Committee of Creditors of Vrindavan Ceramic Private Limited and others, Company Appeal Suenso of 2024. Need not reiterate, this is a very recent judgment. As mentioned in the topic, it is very clear that a resolution plan was approved by CUC, but there was inordinate delay in submission of a petition under Section 30, subsection 6. NCLT looked into the matter and sent the party into liquidation. Obviously, the SRA filed an appeal at NCLAT, and the matter NCLAT took up the issue and analyzed it. This is an interesting read because this deals with a topic, as you can say, that at one point we are saying that liquidation is the last resort. So one should try for the objective of IBC is resolution. But herein what we are saying, if there is an unexplained delay in the resolution process, then in such case, adjudicating authority may order for liquidation despite resolution being approved by CUC. So that is the reason I would implore my viewers to please go through the excerpts of the judgment which is there on the website. But while stating so, let me take you over to the slide which I prepared for you. Now, NCLAT observed that while order dated 21/9/2020, the period of CIP was extended for 90 days till 15/10/2020. Form G seeking expression of interest was published on 11/6/2020. However, no plan was received due to COVID-19 pandemic situation. You can see that it is 2020. The CUC in its fourth meeting held on 5/9/2020 resolved to issue fresh Form G in pursuance of which 3 resolution plans were received. IA number 205 of 2021 was filed by RP before Learned Adjudicating Authority for exclusion of period from 25/3/2020 to 31/5/2020, and while order dated 23/3/2021, same was allowed and the period of 68 days were excluded. The revised resolution plan was ultimately filed by appellant Lorenzo Vitrified Tiles and Vishram Akhai Patel on 7/5/2021 and 8/5/2021. So the revised resolution plan were ultimately filed by appellant Lorenzo Vitrified Tiles and Vishram Akhai Patel on 7/5/21 and 8/5/21 respectively. The entire CIP period of 330 days after exclusion and extension granted by Learned Adjudicating Authority expired on 11/5/2021. That is 3 days after the revised resolution plan was submitted. IA 529 of 2021 was filed by RP for extension of CIP period, and while order dated 10/8/2021, the same was extended till 10/8/2021. So, the plan was within the period of extended CIP. In the 13th COC meeting held on 3/8/2021, CRP approved resolution plan of appellant Lorenzo Vitrified Tiles Private Limited and approved the same. While order dated 8/11/2023, Learned Adjudicating Authority remanded the plan back to COC for its reconsideration in the light of judgment passed by Honorable Supreme Court in Rainbow Paper Limited. So, while order dated 8/11/2023, Learned Adjudicating Authority remanded the plan back to COC. The plan after order dated 8/11/2023 could only be submitted on 5/7/2024 with a delay of more than 8 months, and RP did not seek any condonation of delay or explain the delay, and the application was rejected on the score. The next meeting of COC was held on 6/1/2024, 25/1/2024. It was on the 21st COC meeting held on 25/1/2024. The resolution plan was approved. So resolution plan was approved for when? 25/1/2024. And the petition was submitted on 5/7/2024. That is delay of more than 7 months. A delay of more than 6 months. And RP did not. Okay, adjudicating authority had sent the plan back. So RP should have applied for extension of CIRP. But even after approval of plan of COC on 25/1/2024, the application for approval of the plan was moved with an ordinate and unexplained delay of many months. That is 6 months, as I said. The RP appears to be at fault for not moving application for approval of such plan for many months, and surprisingly no application was moved either to extend the CIP period, which was admittedly expired on 30/11/2023. Thus, in the background of the aforesaid facts and circumstances, there is no illegality in the decision of learned adjudicating authority to initiate the liquidation process of the CD. No good ground of interference in the impugned judgment was passed by learned adjudicating authority, and keeping in view the huge delay running into many months, the liquidation was the only option available before learned adjudicating authority. See, if an RP takes 6 months time to file an application, and it is imperative, okay, the plan was submitted for approval in 2021, adjudicating authority sent it back on 2020. Okay. Then automatically, the first thing the RP should have done is to request the adjudicating authority to extend the CIP period, because it has been sent for reconsideration of the CIP, which was not done. Then COC approved it on 25/1/2024. Still then, he submitted the petition under 30 subsection 6 on 5/7/2024. So there was a gap of 6 months. There was nothing to explain, and he hadn't even applied for condonation of the delay. So under the circumstances, the adjudicating authority has to work within the framework of Insolvency Bankruptcy Code. So he had no other option but to order for liquidation. So this is an exceptional case where a resolution plan, despite being approved, company went into liquidation. And that makes this case special and exceptional. So with this, I take you over to the next slide. We are on the screen of section 43 of Insolvency Bankruptcy Code on Guide to IBC website. 43, as we all know, deals with preferential transaction and relevant time. Relevant time, as we know, has got two parts. If it's a related party, it's 2 years prior to CIRP. If it is unrelated party, then it's 1 year. So our topic of interest is topic number 17, which says that section 43 to 51 of the code are intended to ensure that during the twilight period preceding insolvency, the assets of the corporate debtor are not used to selectively improve the position of certain creditors at the expense of the others. So what is the twilight period? Twilight period is the relevant time. That is prior to its initiation of CIRP period. Our case of interest is Suraksha Realty Limited versus Mr. Vital M. Dahake, RP, and others. This is Company Appeal Suits of 2025. In this case, what happened was debentures were issued. This is a long case, and you can see the the headlines. This is quite a lengthy headlines, and the case is also quite. It is definitely a very interesting read. In short, what happened was there was a debenture issued, and naturally there was a security agreement also, which required the party to create mortgage on the assets, which was not done for 7 years. Subsequently, the company availed loan from Yes Bank and DHFL and created first charge on the property. Then subsequently they realized at the time when insolvency was about to commence, they realized that the charge had not been created. So, without even taking no objection certificate from Yes Bank, they created second charge on the debenture against the debentures which were issued. The RBI considered this to be a preferential transaction and lodged a petition at NCLT. NCLT deliberated upon this and allowed the case. The matter went to NCLAT. NCLAT looked into the matter and came up with this beautiful judgment, which I'm requesting you to please go through. So with this, in order to make things precise and understandable, let me take you over to the slide which I've prepared for you. The DSA was executed on 18/12/2014, and accordingly a sum of 112.50 crores was disbursed to corporate debtor by appellant in consideration of debentures issued by the corporate debtor. The appellant itself has stated that the DSA contemplated further steps and required for perfection of the security, including execution of formal mortgage documents. Understandable. The security, thereby meaning mortgage of the property, was to be done within 30 days from DSA, which was 18/12/2014, which was not done. The mortgage was never created. No charge was created. The deed of mortgage should have been executed by 7/1/2015, that is within 30 days. Secondly, the security was to be the first charge on the property. Obviously, when you create a mortgage, there has to be a first charge. However, no registered mortgage charge or perfected security interest was created in favor of the appellant for almost 7 years thereafter. During this period, the corporate debtor created substantial first charge in favor of Yes Bank in the year 2015 and 2016, and thereafter further encumbrances in favor of DHFL in 2018. Despite being aware of the subsequent transaction and despite claiming that DSA contained restrictive covenants against creation of further encumbrances, the appellant admittedly did not initiate timely proceedings for enforcement of its rights. The appellant kept quiet for 7 years, and when these charges were first charge was created in favor of Yes Bank in 2015 and 2016, and thereafter in favor of DHFL in 2018, they did not create any objection. They kept on. The security executed by corporate debtor in July 2021 as second charge on the portion of property which was held by Yes Bank as first charge from December 15 onwards. So they gave a second charge. More importantly, such security interest was created by corporate debtor without obtaining NOC from Yes Bank, the first charge holder. This makes it absolutely illegal. You cannot create a second charge without obtaining NOC from the first charge holder. Therefore, the transaction undoubtedly improved the position of the appellant in the event of distribution of assets under Section 53. This improvement itself is sufficient to satisfy the requirement of Section 43, subsection 2, subsection B. Having remained unsecured for nearly 7 years and having permitted subsequent lenders to acquire registered security interest, the appellant cannot now contend that mortgage deed dated 29/7/21, was a continuation of already perfected security. Thus, impugned transaction which was not entered by CD 3 months after Section 7 application against corporate debtor was registered in NCLT and barely 2 months prior to commencement of CIRP was a preferential transaction. The mortgage deed dated 29/7/21 constituted a preferential transaction within the meaning of Section 43 of the Insolvency and Bankruptcy Code 2016. There is no doubt about it. I mean, they should have done Suraksha reality. They have been keeping silent for 7 years. The first charge gets created in favor of Yes Bank, and they take second charge. And obviously, this constitutes a preferential transaction. And this is an exceptional case from that point of view. So I'm requesting all my viewers to please go through the judgment as appearing on the website. With this, let me take you over to the next slide. The dashboard of Section 60, topics of pertaining to Section 60 of Insolvency Bankruptcy Code on Guide to IBC website. Section 60, as you know, deals with adjudicating authority for corporate persons. Our topic of interest is topic number 130, which says that in matters of contempt following the due procedure and principle of natural justice is of great significance. Let me read it out again. In matters of contempt following due procedure and principles of natural justice is of great significance. The cases of State Bank of India and others versus Jyoti Structures Limited and others, Company Appeal so-and-so of 2026. This is a very interesting case in the sense that in this case, State Bank and many other banks were held to be contemners by adjudicating authority. And he ordered punishment. I mean, of jail. He passed a jail order against State Bank and other banks. This pertained to release of bank guarantees and LCs, on which was specifically ordered by NCLT in its various orders, which were not abided by. So NCLT held the banks to be in contempt and passed this order. This matter was challenged at NCLT. Since contempt and things are not very common in Insolvency Bankruptcy Code, I would request my viewers to please go through the judgment as appearing on the website. And also, you're most welcome to read it from the actual judgment in NCLAT. But in order to make things understandable, let me take you over to the slide which I prepared for you. The Honorable Court held that power to punish a person for contempt is undoubtedly a powerful and potent weapon in the hands of the court. But it is also well recognized that such power must be exercised with utmost caution and circumspection. That is, court cannot just like that. It has to be exercised with caution and circumspection. That how this has happened. The power cannot be used unless the court is fully satisfied beyond doubt that alleged contemner has deliberately and intentionally violated the order of the court. So deliberate and intentional are very important in holding a person in contempt. In matters of contempt following due procedure and principles of natural justice is of great significance. Contempt proceeding required two-stage process. One, recording prima facie satisfaction before issuing the show cause notice. And two, framing a precise charge so that the alleged contemner is conscious of the case he has to meet. So there comes the natural justice. The contemner must know the charge he has to meet. The court cannot pass a contempt order without issuing show cause notice or giving an opportunity to the appellants to explain the alleged contemptuous conduct. Court cannot issue an order of contempt until and unless a show cause notice is issued. and explain to the appellants that on the contemptuous conduct, the adjudicating authority in this case has directly imposed punishment without first passing an order recording the prima facie satisfaction that there was a contempt. As I said, adjudicating authority ordered jail sentence. So, adjudicating authority in this case had directly imposed punishment without first passing the order recording the prima facie satisfaction that there was a contempt. Further, imposition of punishment without issue of show cause notice to the appellant setting out issues and charges was allegedly constituted contempt on August 20 of NCLT order and December 9 NCLT order, which is procedural breach. See, NCLT order and NCLT LAT order are procedural in nature. And based on this, contempt has been moved. That there were two orders, August 20 of NCLT and December 9 of NCLAT. So these are procedural orders. The minimal requirement for following procedural procedure prescribed by law has been clearly overlooked by the adjudicating authority in present case. The sanction letters have been independently issued by each appellant banks, which sanction terms are variant from each other. Each bank has issued a sanction letter and the terms are different. The adjudicating authority, without going into specific sanction order and identifying how each of them breached the directions of the court, would not have passed a composite order of contempt. So each sanction letter should have been seen. So without looking into that, a composite contempt order could not have been passed against a number of banks. Adjudicating authority could not have passed a composite order of contempt against appellant banks, and that too without naming the specific officers who are charged with the which contumaces which means which has constituted disobedience. It has passed an order naming State Bank and Union Bank and blah 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 banks. So the court should have mentioned specific officers, which are not done. Since contempt jurisdiction has not been exercised by adjudicating authority in accordance with the procedure prescribed by law, in such circumstances, the impugned order cannot be sustained. So you see, a contempt is not an easy thing. And this is a good read because this gives us a full circumspection of what happens in the case of a contempt order. And this makes this case an exceptional read. So with this, let us move on to the next case. Here on the dashboard of topics under Section 66 of Insolvency Bankruptcy Code on Guide to IBC website. Section 66, as we know, deals with fraudulent or wrongful trading pertaining to CIP process. Now, this deals with the element of fraud. Our fraud and wrongful trading comes under the jurisdiction of Section 66, and order under Section 66, actually the punishment is inflicted under Section 67. Now, our topic of interest is topic number 32, which says that Section 66 empowers the adjudicating authority to pass an order that any person who were knowingly parties to the carrying on of the business term, any person's business term, any person may include third parties also. Let me read it out again. Section 66 empowers adjudicating authority to pass an order that only persons who are knowingly parties to the carrying on of a transaction on any of the business term, any person may include third parties also. Our topic of interest is Finbid Investors Private Limited versus Oryx Leasing Financial Services Limited, Company Appeal so-and-so of 2024. Let me mention that this is a recent judgment. This is a very interesting case which has been remanded back by NCLAT to NCLT to rejudge. Herein, the adjudicating authority, third party named Oryx Leasing, NCLT observed that it, Oryx Leasing being a third party, no direction can be passed against it to contribute to the assets of the CD. Herein, the Honorable NCLT considered various judgments of Supreme Court like Goodrich Capital Private Limited versus State of West Bengal, and then Piramal Capital and Housing Finance Limited versus 63 Moons Technologies, then Swapan Kumar Shah versus Ashok Kumar Agarwal. This was an NCLAT. Sangeeta Jatinder Mehta versus Kailash Shah RP, New Empire Textiles. And based on, and other judgments also, to determine as to state that in the case of 66(1), if a fraud has been committed, a person knowingly has or contributed to the commitment to the commissioning of the fraud, even if he is the third party can be implicated and can be called to reimburse the company of the loss that has occurred there. Now, in this particular case, what happened was Oryx Leasing had leased certain properties to the CD. It had just prior to commencement of CIRP, or it had asked the CD to make the payment, and when the CD made payment, since CD had failed to make the payment, it had adjusted the security deposit. Unfortunately, the security deposit was adjusted during the CIRP period, which violated the moratorium. So, adjudicating authority was of the view that the RP should file a separate petition for that purpose. There was also a master leasing agreement pertaining to, there was also some issues concerning supplying of materials to other parties. The other parties, the supply, there were terms in which it said that the machine should get supplied, but the order will be procured by the CD and will be given to Oryx. So Oryx will supply and collect the payment and give it to the CD, and CD will disperse, which did not happen in many cases. The master lease agreement, and whether the master lease agreement was a sham document or machines were supplied to this Pratiksha Link CD could effectively adjudicate it, these things were not adequately dealt upon. So the matter was remitted back to adjudicating authority to dwell upon it and pass on a relevant judgment. But since it concerns whether a third party can be implicated, this case makes it special. And in very brief, whatever I have stated, if you go through the judgment, you will get an in-depth view of it. But for the sake of the presentation, and to make it precise, let me take you over to the slide which I prepared for you. It depends on the facts and circumstances of each case as to whether a particular person or entity is a third party to avoid liability under Section 66(1) of the Code. We know that Section 66 comprises of two parts, 66(1) and 66(2). 66(2) deals with the erstwhile management or board of directors of the company, whereas 66(1) is a general clause in which even third parties can be implicated. Though Oryx Leasing prima facie appears to be a third party, the matter is kept open for determination of the learned adjudicating authority. A notice dated 6/8/2019 was issued by Oryx Leasing to CD for payment of outstanding lease rental to the tune of 34 lakhs 80,552. As soon as and soon thereafter, the security deposit of 74 lakhs 49,947 deposited by CD was forfeited. The CIRP against CD was initiated on 23/9/2019. And Oryx Leasing, via an email dated 29/6/2020, has categorically admitted that security deposit was adjusted against lease rental of 31/10/2019. So it is after commencement of CIRP. Therefore, the security amount was forfeited by Oryx Leasing after commencement of moratorium with effect from 23/9/2009. The request has been made to Oryx Leasing for payment of pertaining to these machines to Pratiksha Trade Link. Whereas in master lease agreement, the machineries were supplied at the instance of Oryx Leasing to CD, and payment for such finance was to be made by Oryx Leasing, which I say. False statements have been given by directors of CD in terms of machines supplied were defective and were returned to the supplier, and also the fact that the machines have not been found with the CD. Learned Adjudicating Authority observed that master lease agreement was a sham and was entered into to defraud the creditors, and further hold that respondent number 2 and 2 to 5 are liable to contribute entire money paid under master lease agreement. However, the amount to be paid under MLA has not been specified by the RP in the application, and direction was issued to the RP to ascertain the same. The matter could effectively be adjudicated after considering fresh documents which have been placed by CD before appellate tribunal. The matter is remanded back to adjudicating authority for considering it afresh and providing opportunity to the parties to file any documents in support of their claim and defense. So what we find is that adjudicating authority has considered and held that master lease agreement was a sham document, and the entire thing was to defraud the creditors, and that amount paid under master lease agreement had to be paid by respondent number 2 to 5. But the adjudicating authority did not determine the amount and asked the RP to determine it. So the order had not attained finality. So, and in the appeal, new documents surfaced. And NCLAT being an appellate authority cannot take the role of NCLT. So accordingly, this had to be rejudged again. And adjudicating authority was asked to look into it, take a firm decision on the whole thing, and also automatically following the rule of natural justice. The liberty was given to other parties to file their defense and file their claim and defense accordingly. So this is a nice case. Why this is mentioned is because in 66(1) we are holding the third party also responsible. So that is why this case is exceptional. So with this, we move on to the next slide. We have come to the conclusion of our podcast. I hope you liked it. Please give your likes and comments, because your comments and your likes do motivate us a lot. I hope you remember that during the month of June, there may not be regular podcasts that we do, because we'll be updating our website with new amendments to Insolvency Bankruptcy Code, as well as various regulations which have come into force. So with this, bye. I wish you bye to all the viewers.